In 2012, an Oregon man was sentenced to jail for collecting rainwater on his own property. That's the headline that has circulated online for more than a decade. Proof, supposedly, that the government will lock you up for owning a rain barrel. Almost none of it is true. What actually landed Gary Harrington in a Jackson County courtroom involved 3 earthen dams, 2 boats, a stocked trout pond, and 11 straight years of him ignoring a judge. By the end of this video, you'll know exactly where the rainwater felony myth came from and whether the rain barrel sitting outside your own house could actually get you arrested. Here's why this case refuses to die online. Water in the United States isn't governed by one federal law. The Constitution leaves it entirely to the states, so America runs on 2 competing legal systems at once. In the wetter eastern states, water rights are tied to your land under something called the Riparian Doctrine. If a stream touches your property, you get a reasonable share of it, permanently, no matter how much you use. But in the drier western states, water works under prior appropriation. The first person to put water to use owns that right, forever, ahead of everyone who comes after them, even if that water is falling from the sky on someone else's roof. Gary Harrington lived in Oregon. He was about to find out exactly how far that second wall extends. Harrington owned 172 acres inside a watershed called Big Butte Creek in southern Oregon. Over several years, he didn't set out a couple of plastic barrels under his gutters. He built 3 engineered earthen dams. 2 stood about 10 feet tall, the third climbed to nearly 20. Behind them, he impounded roughly 40 acre-feet of water, about 13 million gallons. To put that in perspective, that's close to 20 Olympic-sized swimming pools, sitting on private land in the hills of Jackson County. And these were quiet holding tanks. Harrington built boat docks. He kept actual boats on the water. He stocked the reservoirs with trout and bluegill for recreational fishing. His defense from the very beginning was simple. This was just diffuse surface water, rain and snow melt that happened to land on his own soil, and therefore his to keep. The state of Oregon disagreed, and it had a specific reason. Under a 1925 law, all the water in the Big Butte Creek watershed had already been reserved, not for Harrington, but for the city of Medford's public drinking supply. Regulators determined Harrington's dams weren't just catching rain that fell on his land. They sat directly across natural channels, physically blocking a tributary called Crowfoot Creek before it could ever reach the river system Medford depended on. In 2003, state water managers briefly approved his permits. Then, weeks later, they reversed themselves and denied all 3. Harrington had 60 days to appeal that reversal in court. He let the deadline pass. That single missed deadline mattered more than almost anything else in this case. In 2004, a water master, the state official responsible for enforcing water law on the ground, posted formal notices on Harrington's property, ordering him to open his dam gates and stop storing the water. Instead of complying, Harrington sued the state in circuit court, arguing regulators had no jurisdiction over surface runoff in the first place. But under Oregon's Administrative Procedure Act, once an agency issues a final order, challenging it in a separate lawsuit isn't allowed. You have to appeal through the official review process on the official clock, and Harrington had already burned that clock in 2003. In 2007, the Oregon Court of Appeals threw his case out on exactly that technicality. For most people, that would have been the end of it. Harrington kept going. He pled guilty to 1 misdemeanor water violation in 2008 and kept the dam standing anyway. Here's the dry observation this case earns honestly. A man spent 11 years fighting the state over whether he could legally own 2 boats and a stocked fishing lake. And somehow, the internet remembers him as a guy with a rain barrel. By 2012, prosecutors in Jackson County had had enough. Harrington was charged with 9 separate misdemeanor counts, illegal use of water denied by a water master, unauthorized use of water, and interfering with a lawfully established headgate. Not one felony charge appeared anywhere on that list. At sentencing, Jackson County Circuit Judge Lorenzo Mejia wasn't buying Harrington's framing of himself as a property rights martyr either. Most people, the judge noted, at least promise not to repeat a crime once they're caught. Harrington had done the opposite, defying court orders for over a decade, and, in the judge's own words, being dishonest with the court along the way. The state's water master put it even more bluntly. Water law is water law, whether you agree with it or not. 11 years of permits, appeals, missed deadlines, and warning notices were about to come down to a single sentence. Harrington was convicted, not of a felony, of 9 Class B misdemeanors. The judge handed down 30 days in county jail. Not years, 30 days. He was also fined $1,500, and he was ordered to breach his own dams and drain all 3 reservoirs. That's it. That's the entire rainwater felony the internet has spent over a decade warning you about. No federal charge ever touched this case. No felony conviction exists anywhere in the record. A real felony under Oregon or federal water law is reserved for something else entirely. Tampering with a public drinking water system, which carries up to 20 years in federal prison, or stealing municipal utility water worth more than $950, which California treats as grand theft. Neither of those describes a homeowner with a barrel under a downspout. Harrington built a private lake system that blocked a creek feeding a city's water supply, ignored 11 years of legal process, and walked away with a misdemeanor and a month in county jail. So what does this actually mean for the rain barrel outside your own house? In most of the country, nothing to worry about at all. There is no federal rainwater law. The Clean Water Act regulates pollution in rivers and streams, not a homeowner catching rain off a roof. Only 3 states, Colorado, Utah, and Nevada, impose real statewide limits, and even those are modest. Colorado caps most households at 110 gallons across 2 rain barrels, while Utah lets you store up to 2,500 gallons before you're even required to register. Texas and California go the other direction entirely. Texas legally bans HOAs from prohibiting rain barrels, and California exempted rainwater systems from property tax increases outright. The one genuine legal tripwire that survives across almost every western state is where you catch the water. Rain off your roof through your gutters is almost always yours. The instant that same water hits bare ground and starts running toward a stream, it can legally belong to someone else entirely. Sometimes a water rights holder you'll never meet, miles downstream. So here's the actual question worth arguing about in the comments. Should water that falls from the sky ever legally belong to someone other than the person standing under it? Before you go, subscribe. This channel digs up one case like this every week. The ones that get flattened into a headline online and completely rebuilt once you read the actual court record. And next time, we're staying in the fine print, the clause buried in most terms of service agreements that quietly hands a company a permanent license to everything you post, whether you ever read that sentence or not.